Abusiancho na yamo kwaba. Unim se ensema ye wanim sem dada. A che se oro ne kopiem ra shebedwafia nyasam to NDC and PPD because of the 4 vacanter the Speaker of Parliament editu da che se omuntimi ni djuma biemu no kopiem e wo Supreme Court ne de ye kase ya no omugusu a che se gitanwudie ne niam ahodo ekoso a ipututu ni ade a na abusian obia yesi aboa no wo ba bia ekopem obia wo ba bia ne krache power ne tumi no epemo na ebra Speaker of Parliament one ne lawyers epie mo wo Supreme Court na judges bisa nsamba kumiyenu mi ensa no me say no oye speaker or limits because yen name so my Ghana nyina no the highest decision body aye the Supreme Court it is what kasem na asa wutie asa wuntie o de wada I just say come say mbu esefata no won fa ma Supreme Court na busia ensem bia pie fi mo baba e brand trase no ekoye ensem bia pie fi mo ba no odin na mepese ye gibre na yekotie de koso ewo ye Supreme Court wo efa enipa enan a moye member of Parliament sitting a ma chese bibinti emu ba ko chese onkwa NDC biem ebi so chese onkwa PP biem independent kan woni ade a eno ana chese speaker chese eye vacant edu omuntimi medi dwuma se mrahye bedwafo ewo various parties no edimu biem and ekwabasa so achese niema besesa no na atofo se de call ye mrahye bedwafi Supreme Court na asem ne nsem epie free mo bana no odin yes allegedly bi mukura chese speaker kra no ye niema bia to favor NDC said by ombetimi anya position bia na so ombetimi asemre bia ni kwa so ombese because esa nipa for friend PPD ne train friend PPD so in other way na chese NDC ekwa majority no na atofo sende koye no ana Supreme Court chere emra wo my Ghana mo wose yetimi edi so di atentre ne yenjembre na yentie mu nsema kasa mesre chere wo comment section of maye owie so na waso sky channel no medin Eddie Robert obetimi afreme Robbie me ne me champion cameraman Kobi ana edi wenyina bro yebre ne enkotie de ekoso ewo Supreme Court one.
The constitution of the country has been unlawfully upset. The second point I make respectfully is that everything in the Constitution, from the regulations affecting the performance of the Electoral Commission's functions, in Chapter 7, up to the composition of Parliament, or the entire chapter on the legislature. The entire chapter on the legislature in Chapter 10 shows that Parliament, when used, refers to a specific term.
Hold on, the word Parliament.
Parliament, the word Parliament. Parliament, when used, refers to only one term of Parliament in session and nothing more. And that when the people of Ghana respectfully also elect a member of Parliament, when the people of Ghana vote in the election of members of Parliament, that election is for only one term. And they do not have in mind the election of members of Parliament beyond the term of Parliament for which they voted. Well, I refer to Article 113. Article 113 clause 113 clause 1 of the Constitution. And it says quickly, subject to clause 2 of this article, Parliament shall continue for 4 years from the date of its sitting and shall then stand dissolved. Clause 2 respectively provides that at any time when Ghana is actually engaged in war, Parliament may from time to time, by resolution supported by the votes of not less than 2/3 of all members of Parliament, extend a period of 4 years, specified in clause 1 of this article, for not more than 12 months, except that the life of Parliament shall not be extended. So clearly, Parliament is for only 4 years and nothing more. My lady, this is further reinforced by...
Excuse me. Can you turn to page 24 of your statement of case, please? (23 and 24).
On page 23.
Paragraph 32 and paragraph 33.
Yes.
Is what you are saying there?
Yes, Mr. But I will further, and they don't allude to clause 2 of Article 97, which I'm coming to. Especially, and clause 2 of Article 97 is very important. As well, the point I make from all of this is that anything that affects the composition of Parliament for a future Parliament which has not yet been elected is unknown to the Constitution. The Constitution does not anticipate that all the matters set out in Article 97, Clause 1, including J and H, which are an issue before the court today, have any bearing on matters beyond the life of a current Parliament. They have only consequences insofar as the current Parliament is concerned with. Respectfully, apart from the clear or the indication in the language of Article 97, Clause J, which talks about a person seeking to remain in Parliament, I will refer the court to Article 97, Clause 2, which has not featured so far in the argument before the court. Article 97, Clause 2 is in these terms: notwithstanding paragraph G of Clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitutions or membership of a coalition government of which his original party forms part shall not affect the status of any member of Parliament. So the point being sought to be made from Article 97 Clause 2 is that even a merger of political parties in the life of any Parliament has no effect whatsoever on the status of a member of Parliament. Thus, if today the NDC and CPP, respectively, come together, okay, because I don't want to see, okay, sound right. but so I would prefer a merger between the MPP and CPP, as occurred in 1996. So, respectfully, indeed, the implication is that if in the first Parliament of Ghana, the MPP had elected to contest parliamentary elections, which we all know from history that it did not, and in the course of the life of that Parliament, as actually occurred, a merger between CPP and MPP occurred, the status of a member of Parliament selling a ticket of MPP as an MPP MP shall not be touched, shall not be affected by the Constitution. So if indeed MPP and CPP had come by an arrangement, as they did actually in 1996, that for the Parliamentary constituency, the MPP will not contest, and the CPP rather will contest, which indeed was the case. But the MPP at that time already had a sitting member of Parliament in the Parliamentary constituency, and by virtue of that had more or less ceded his interest or right to a CPP member. Respectively, that would not necessarily result in a vacation of the seat of the member of Parliament. So if indeed on account of Clause 2 of Article 97, it has been decided that for constituencies already held by the MPP, for the purpose of the upcoming election, those candidates or those members of Parliament shall contest on a ticket of CPP or a different political party. Article 97 Clause 2 suggests clearly that the status of such members of Parliament as MPs shall not be altered. So especially this, in my respectful view, fortifies the proposition we make that any decision by a member of Parliament to change his political identity for an upcoming election shall not necessarily result in a vacation of that member of parliament seat. I don't know if I'm making myself clear. I'm moving. So, right. So, apart from that, I'll refer the court to Article 47, Clause 5 of the Constitution, which is also a further indication. 47, Clauses 5 and 6 of the Constitution, which talks about alteration of the borders or boundaries of constituencies. So the point is that the Constitution, as I indicated, anticipates that the change in the composition of Parliament or the change in an anticipated composition of Parliament in the future shall have no effect presently. And that's supported by Article 47, Clause 5, which vests the Electoral Commission with the power to review the divisions of Ghana into constituencies at intervals of not less than 7 years, especially as we stand before the court. Indeed, the number of constituencies for the upcoming 2024 elections has been altered by the Electoral Commission. Rather than 275 constituencies, we will have 276 constituencies in the December 2024 elections because of the alteration of the boundaries of the Boem constituency, with the result that there has been a creation of a new constituency for what we call the South people, the Santo Kofi, Lolobi, and Akpafu area. Clearly, the alteration of the boundaries of the existing Boem constituency now has not affected the status of a member of parliament sitting as MP in the Boem constituency. That alteration only has effect in the December 2024 elections. So the point I'm making is that it is so clear from the Constitution that whenever a member of parliament decides to change his political identity, or indeed the Constitution itself seeks to enforce a change in the composition of Parliament for the next election, it has no effect in the current term. If that were the case, presently, the South people would vote now and elect their MP, but they cannot vote now and elect their MP. They must wait until December 2024. I'll quickly wrap up with a swift address of issue 3, which is whether or not the declaration by the Speaker of Parliament of 4 vacancies.
I have a question.
Right.
And my question is, what is the point of the provision in Article 97(1)(g)(h)? Why did the framers of the Constitution put them there?
Right. Right.
I know you have addressed it in your, if you don't mind. I know you have addressed it in your submissions, but I think that by reason of the last point made regarding Article 47(5), we need to have some light shed on
it. So the purport of Article 97(1)(g) is to prevent situations where a person in the life of a current parliament seeks to alter his political identity. That is frowned upon by the Constitution. So that if a person comes to parliament or having been elected as member of parliament for a specific term as an MPP candidate or whatever political party candidate, in the course of the term of that parliament wishes to move to a different political party, the Constitution says that's prohibited. If the person also seeks to continue, and that is indicated by the use of the word, seeks to remain in parliament, if the person seeks to continue his tenure as an MP during that term of parliament as an independent candidate, that's prohibited by the Constitution. Am I ready? Indeed, such situations have occurred in this country. It is not without history or antecedent. So clearly, the Constitution anticipated a change of one's political identity within the term of the current parliament, and not an anticipation.
Mr. Dami, can you give us 1 or 2 instances where
such occurred?
Exactly. Historical antecedents.
Right. Especially in the first parliament of Ghana, there were about 3 or 4 instances whereby in the first parliament, there were 3 or 4, no, the first parliament, 1960, under the 1960 constitution, there were 4 instances in which some members of parliament cross-carpet or changed their political identity. There were the cases of J.A. Brima, Mumuni Baumia, Tampuri, and the Torona. They cross-carpet from the then governing CBP to join a different political party. Others also cross-carpet from the opposition party to the governing CBP. In view of that, the court would note that the 1960 Constitution had no such provisions at all. In view of that, for the very first time in 1969, a provision to that effect was enacted. And I refer the court to Article 75, Clause 2, Paragraph G of the 1969 Constitution in the Assembly, upon the resolution of the National Assembly. A member of the National Assembly shall vacate his seat in the Assembly if J. he leaves the party of which was a member at the time of his election to the National Assembly to join another party. This was the first time, the Second Republic, that a provision like that was introduced. The provision again was repeated in 1979 Constitution, and it was at Article 79. Article 79, Paragraph I of the 1979 Constitution. It says, a member of Parliament shall vacate his seat in Parliament in I, if he leaves the party of which he was a member at the time of his election to join Parliament, to join another party. At the time of his election, to join another party. So that's it. Then the provision was repeated in 1982. When a situation like that occurred, and I refer the court to the circumstance of Alhaji Wayo Seni, Professor Wayo Seni, who cross-carpet from the party on the ticket of which he had been elected as member of Parliament to join another political party. At that time, the Speaker of Parliament indeed rightly ruled that he had vacated his seat. Especially, this situation that we find ourselves in before the court had again occurred in Parliament, in the 7th Parliament. The Speaker of Parliament, just like the current Speaker, ruled that he had no vacation of seat. My respectful submission on that point is that such ruling was erroneous. The ruling that affected the status of Honorable Isiama Maridi, I love because the gentleman suffered a lot. The last Parliament, he was declared to have been to have vacated his seat. This Parliament again, too, his seat has been vacated. One person. He suffered a lot. So, my lady, and my point is that no matter the number of times an unconstitutional act is repeated, it has not ripened into constitutionality. This court has said in numerous cases. Yes, this court has said in numerous cases. It started from Tufo and Atejara up to the recent matter, an ex parte charge also. Yes, ex parte charge. 2007-2008, Supreme Court of Ghana report, volume 1, at page 213. That an unconstitutional act, no matter the times repeated, especially, does not ripen into constitutionality. So the fact that the previous speaker had ruled that Mr. Esiama Mwaku had vacated his seat and that is being sought to be used as a precedent today, does not mean that it's constitutional. Especially, I'll be done on this case.
You had only 3 issues.
Yes.